Yes, Mr. Marshall.
Please, your Lordship, I appear on behalf of the appellants in this matter. Ms Hilliard, King's Counsel, and Mr Watson, King's Counsel, appear on behalf of the respondents. As your Lordship will no doubt know, having had the materials in advance, that this is an appeal against the order of Mr Simon Gleeson, sitting as a Deputy Judge, dated the 8th of September of last year, in which he struck out the claim form and particulars of claim as disclosing no reasonable cause of action. The appeal and a respondent's notice, which has been served, raise issues falling into three broad categories. The first is whether an event of default occurred under a guarantee and debenture, which is a topic covered in grounds 1 to 4 and 6 of the Notice of Appeal. And that involves determining whether, on the true construction of certain information and notification provisions in the debenture, there was any default, an event of default, supporting the appointment of the respondents as administrators. Within that topic, there really are four things just to highlight. Firstly, a question of construction of the provisions of the debenture that relate to notification and information and related provisions. Secondly, consideration of whether a request for information was actually made and having regard to events which are said in the respondent's notice to have required notification, whether those things fell within those relevant provisions as properly construed. Thirdly, even if the request for information potentially did fall within those provisions, whether it in fact actually fell outside of them, having regard to equitable or implied restrictions on the use of a power to request information in the debenture where that request was made in bad faith or for an improper purpose. And then fourthly, whether, in relation to really all of these matters, that the position is so clear that no trial is warranted in connection with them. So that's the first broad category. The second is whether the appointment of the respondents as administrators was invalid because, as we contend, it was carried out in bad faith and for an improper purpose. That's essentially ground 5 of the grounds of appeal. And again, of course, involves the question of whether the position is so clear that no trial is warranted in connection with that. And then there's a third category, which is whether, even if we are right about the appointment being invalid, we are stopped, the appellants are stopped from pursuing a claim. And of course, whether within that is the question of whether that matter is so clear as to warrant effectively a summary determination as opposed to the matter going to trial. Now, I propose to address the issues within that broad order, and we respectfully submit that if we are actually right about the construction, the true construction of the provisions of the debenture and the information and notification provisions in it specifically, if we're right about that, then it actually isn't necessary to determine anything really related to issues concerned with bad faith or improper notice, because if we're right about the construction of the information notification provisions, the appointment will have been invalid. We still would have to deal with the estoppel, but as I'll submit in due course, that is a particularly weak part of the respondent's case, and indeed we would submit, in fact, some points in that regard could be resolved summarily in our favour rather than theirs, but we'll come to that in due course. Now, just one matter which I just wanted to draw attention to at the outset. In terms of the procedural position, we're in a slightly odd procedural position in this case because the judge's order was to strike out the claim form and the particulars of claim.
Yeah, but the substance of his reasoning was to grant reverse summary judgment.
It was indeed. It was indeed. It's a somewhat odd scenario. The only reason I draw attention to it is that the judge seems to have thought that you approach the two applications in an identical manner. And with all respect, we say that's wrong, because when it is a strikeout application on the basis of, as it was put here, disclosing no reasonable cause of action, I think it's in Rule 3.42a. When you've got an application like that, you don't actually look at the evidence, you're just looking at the pleading and the claim form and seeing whether, as a matter of law, they stand up. It's only in the context of a summary judgment application that you would then go on to look at the evidence. So there is a distinction between the two things. And the only reason I draw attention to this at this stage is because when we raised it on the permission to appeal application, there was then a supplementary judgment, which your Lordship may have seen, where the judge sort of maintained his position that really there's no distinction between the way in which you deal with both things. And we respectfully submit that's not correct. And it may be that the court will wash.
But as I understand it, you accept that what you need to show is that he was wrong to grant reverse summary judgment.
Yes.
Because if he was right about that, the fact that his order was misexpressed doesn't go anywhere.
Yeah, I entirely accept that, just as in Three Rivers, in fact, what happened there is exactly what has happened here. You can treat, for present purposes, we accept this as a summary judgment case rather than just a strikeout case.
Yeah.
But I just draw attention to it because your Lordship may want to correct the misdescription of the process, if you like, in the judge's judgment, which we submit is not accurate, not in accordance with the well-established position. Just for your Lordship's reference, the correct description of the position is set out in the speech of Lord Hutton in the Three Rivers decision at paragraphs 115 to 120, which is in the authorities bundle. Now, I'm sorry that you've been having various things sent to you late on, and I think the bundles may be in varying numbers of volumes, but I hope the tab references and page references will still work. And this authority, Three Rivers, is in tab 7, and the relevant passage is at 351 to 352.
Thank you.
Just before embarking then on the categories of issue which I've just described, if I could just deal with just one or two housekeeping matters. First of all, we have agreed a division of time.
Good.
And the proposal is that I finish by 3:30 today. Ms. Hilliard and Mr. Watson then continue, I think, until 3 o'clock tomorrow, and then that would leave me with the balance of the time to deal with the reply. I would only just say there may be a need for a little bit of flexibility in terms of whether I use time that is set aside for my reply in opening rather than in reply. So if I use up any more time, it can be deducted at the end. But overall, I won't be using any more time up than is allotted under that agreement. And I hope that is acceptable to your Lordship.
Yep.
And then the other matter I just wanted to mention is that there are one or two supplementary documents that have gone into the bundle at the rear and also in the authorities bundle towards the rear, and I hope that those got through to you, and also the electronic bundles were sorted out.
Yes.
So,
can I just ask about the other bundles? Because I'm not sure if I kept control of the different other bundles. What should there be? There's a core bundle and a supplementary.
there is indeed.
What should be in those? How many pages for a start?
Core bundle, I think, has remained as it is, save that a supplementary skeleton argument from our side was added at the end at tab 13, and that's at pages 169 to 175.
And there's no tab 12.
There's no tab 12. There's several tabs that seem to have been inserted for things that actually haven't been used. Yeah.
What about the supplementary? Where are we in that?
And the supplementary bundle, we are up to, I think there are 3 documents that have gone in towards the end.
4 tabs.
So there is a tab 53 that was added, which has got a letter dated the 20th of September 2019. It's an important letter from our perspective. And then there's a sealed application notice, which I think has gone in at tab 54, page 334, which just shows you the form in which the relief was sought in the proceedings below.
And is there a transcript being taken of these?
Not other than on the master tape. I'm sure if anyone wants to call for that, it can be obtained through the usual court transcript mechanism. With that, can I now just draw attention to just a few points, key points really, within the factual background, which we say is important for the purpose of considering the first category of issues, and indeed others as well. And if I may, I'm going to just begin with a few points about the origin of the loan documentation and security documentation, which is at the heart of the proceedings and which is the focus of the appeal. Essentially, as you'll have seen, the appellants ran a startup technology business, began in 2017, and involved an application which interacts with the MasterCard system, allowing customers to save and exchange between currency and perhaps what's specific to this business, gold bullion. And like many other such companies, they were dependent on funding from investors and lenders at its early stage. And these investors and lenders included a vehicle, seems to be a special purpose vehicle called Brahma Finance BVI Limited. And it, in fact, held both roles, both lender and investor. And it would appear that it was approached for finance after a shortfall in funding towards the end of 2018. And there was a need for some additional working capital to meet requirements in that regard in January and February 2019. And I should just say that the evidence really outlining what I'm summarising is contained in a witness statement of a Mr. Strong, paragraphs 15 and 16, which is in the supplemental bundle, tab 53, page 283. I don't think it's necessary to go through it, it's just part of the background. But what is necessary just to look at, if we may, is the facility agreement of the 22nd of May, 22nd of January 2019, which we have in the supplemental bundle at tab 2, page 5. And if I can just draw attention to certain key aspects of it, and you'll see the parties and recitals and then the opening definitions in that agreement set out on page 6. And if I could just draw attention to a few features of it. Firstly, in the definition section, 4th paragraph up from the bottom of the page, you'll see that the loan was for £1.65 million, and it is a very short-term loan in the sense that it's got a repayment date of January 2020. So it's actually a loan for something less than a year, just less than a year. And one also, while one's on that page, will notice that event of default is listed in certain subsequent clauses, 11.1 to 11.8. And there's also a definition of finance document, which is important to just bear in mind because it's used and adopted elsewhere, including in the debenture. And a finance document includes not only this agreement, but also a security document. And a security document, as one sees from the final definition on page 6, includes the guarantee and debenture. Now, I said that Brahma Finance was not only a lender, but also an investor. And one sees that from a variety of different provisions which refer to it holding warrants. And some of those are contained on the condition section on page 7, the next page. You'll see reference to the warrant instrument in clause 3.1. And if I go on to clause 11.9 on page 11, there's a little bit more about it. And it's towards the end. There's a reference to issue and allot the number of shares under the warrant instrument to be issued by the borrower in favour of the lender as warrant holder. So it was going to be holding warrants in addition to being a lender, with those warrants carrying the right to the issue of shares. And there's a little bit more about the warrant instruments just to complete the picture on page 13 in a schedule of conditions where you'll see reference to the warrant instrument which was to be executed in favour of Brahma in paragraphs 2.4 through to 2.6. And a number of pieces of information were provided to Brahma at the outset. And if I could just draw attention to some of those. And one finds some of these under the heading of representations and warranties, which appears on page 9, clause 9. And there's a reference to, in 9.7, information in written or electronic format supplied by or on behalf or on its behalf to the lender in connection with the loan and finance documents, and warranties that this information was complete and accurate and so on. One sees that from the top of page 10. And there's also then in clause 10 what are called lender's rights. Whilst any part of the loan is outstanding, the borrower shall provide notice in advance in writing to the lender of any meeting of the board of directors of the borrower, allow a representative of the lender to attend such meeting and join in discussions, but not to count in the quorum nor vote in any matter. And just to also add to the information being provided, among the materials that were the subject of the warranty, which we've seen reference to in clause 9.7, one has what is called financial information, which is set out on page 13 as part of the schedule. And in clause 3, financial information, one sees that what was provided was the latest management accounts and a copy of the audited financial statements for the trading period ended in December 2017. Now, one sees also from the document on page 11 that where notices were sent to Brahma, a particular individual was to receive them, and that was a Mr. Nicholas Barham, who seems to have been based in Monaco, and one sees reference to that in clause 12.1 at letter C, where his details are there given. And it's notable that in the materials, one sees very close and frequent contact going on between Mr. Barham and the directors of the appellant companies. A number of examples of email exchanges, really where they're exchanging day-to-day information about the running of the companies. Some of that related to what was going on with regard to a party who was interested in acquiring the loans and which ultimately seeks to call them in and which results in the dispute. But there's also other material as well. If I could just show you one example, if we go to tab 11 of the supplemental bundle, page 52, one sees in May 2019, Mr. Barham is asking, it's really a question which is in the subject line of his email towards the lower half of the page, whether some money has come in, and Mr. Cousins, who is the director of one of the, on behalf of one of the appellant companies, is responding about the agreement only being signed on a particular afternoon, wouldn't expect it until a certain date, and then a later email a little bit later on the same day confirming that the funds have arrived. This seems to be actually a reference to money arriving from a investor called Sprott Inc., who supplied, I think, some £2 million in funding during the course of 2019. And this is set out in the witness statement of Mr. Strong that I referred to earlier at paragraph 18. And just going back again to the facility agreement, just a couple of other things just to mention about it. It contains some quite unusual provisions about the payment of interest, in the sense that the interest was in fact going to be paid up front and was not going to be refundable. And one can see provisions for that. One goes back to the facility agreement in tab 2, and we go to clause 5.1 on page 7. There was a 12% interest rate, and then clause 5.2, interest shall be prepaid, and the amount shall be deducted from the loan drawn down pursuant to clause 4.1. And then if we go on to clauses 6.2, I think it is, on page 8, there's an ability for the borrower to prepay part or all of the loan, but you don't get a return of the interest that's been paid.
That's in 6.2 at the bottom of page.
Sorry, previous page, yeah, 6.2. And there is also a prepayment of a fee, as well as one sees from clause 7.2. So there was no incentive to repay the loan at an earlier date than January 2020, even if funding was available to do so, because all the interest had already been paid for it and was not going to be refundable. Now, I can just summarise the position. We would respect to submit, looking at the provisions as a whole, this was not in any sense a standard loan. It was a loan of a party who was also an equity investor. It was a very short-term loan, in respect of which the lender had, before making it, obtained up-to-date financial information, including the latest audited accounts and the latest management accounts. And perhaps most unusually of all, the lender was going to be able to participate in all board meetings and would have the same level of knowledge thereby as many of the directors. Now, if I then turn to the security document, that's the debenture and guarantee, which we have in the supplemental bundle at tab 3.
Sorry, is there a provision for providing information to the person attending the board meetings as a director would get before the board meeting?
Let me just check. I think there's certainly provision for them to receive notice and to be able to participate. I think it's join in discussion.
I couldn't see another.
But not any further than that, I don't think. We would respectfully suggest implicit in it, you're going to be able to get notice. You get notice of whatever the notice contained, which would be presumably the proposed resolutions and any accompanying materials. Sorry, I was just about to go to the guarantee and debenture, which is in tab 3 at page 16. And this also contains guarantees from the second and third appellants for the lending. One sees from page 18 there are various definitions. Events of default is defined in the same way as in the facility agreement. But then importantly, there is also a definition of secured assets. All the assets, property and undertaking for the time being of the obligors subject to the security created by or pursuant to the deed, and references to the secured assets shall include references to any part of them. And then, if we then go forward to the provisions which the judge regarded as giving rise to a breach, we have in clause 7 on page 21 a provision about covenants by the obligors. The obligors covenant with the lender that during the security period the obligors will at all times and as applicable undertake and refrain from undertaking such actions as is set out in schedule 3. And if we then go to schedule 3, which begins on page 34, if we go forward to page 36, we will find a heading Information 1.11. And the provisions which are key for our purposes begin here with the obligor shall, and then it's 1.11.1, give the lender such information concerning the location, condition, use and operation of the secured assets as the lender may require. There's then a further provision in 1.11.2. That wasn't one which the lender judge considered to have been breached, but it's important just to have a look at it, just to see how the definition of secured assets works in conjunction with these provisions, because it provided permitting any person designated by the lender and any receiver to enter on or be on the premises and inspect and examine any secured asset and the records relating to that secured asset at all reasonable times and unreasonable prior notice. And then we have 1.11.3, which is a notification provision, which the learned judge didn't consider to have been breached, but which is now relied upon in the respondent's notice. Promptly notify the lender in writing of any action, claim, notice or demand made by or against or in connection with all or any part of the secured assets. And then there's a reference to things with the passage of time, which may give rise to that with the passage of time. So we respectfully submit the definition of secured assets, which is really quite central to the appeal, is on its face one which will have a different meaning depending on the context. It could be a reference to all or part of the secured assets, depending on how the wording of the relevant provision appears. And that seems to have been accepted by the learned judge. That's something he addressed in paragraphs 38 and 39 of his judgment. And there are a variety of different types of assets which come within the rubric of secured assets, which could be referred to depending on the context. Some of them are tangible assets, property assets. Some are intangibles. The types of thing being dealt with are set out in clause 3.1. Where one has different types of fixed charge, particular types of asset being described, and one sees the different categories of what may be covered on that provision, which is pages 19 through to 20. Now, just returning to page 36 and the key provisions that we are looking at, we respectfully submit it's not surprising that certain of the provisions, including these ones, can only be sensibly interpreted as referring to certain types of asset, and we submit the ones referred to in 1.11.1 and 1.11.2 are fixed assets or tangible assets. That's not at all surprising, because the evidence before the judge, in the form of the witness statement to Mr. Strong, paragraph 118, which is in the supplemental bundle at tab 53, page 309, is that the debenture itself was drafted by reference to security documents in relation to real property.
Just test that with 1.11.2.
Yes.
Because one has to read in to the phrase any secured asset, the definition you find on page 2 of the debenture.
Yes.
Which includes the undertaking. So what's so unusual or counterintuitive about permitting the lender to enter the premises and inspect and examine the undertaking and the records relating to the undertaking, which would include, for example, all floating assets, all assets subject to a floating charge that were on the premises? Is that so disingenuous?
All I think we're suggesting is that this, and there are other provisions as well that don't sensibly work with intangibles. They more sensibly work with tangibles. And where one's examining the secured asset in premises, you would expect that more logically and normally and ordinarily to be referring to something like stock or something physical that you're looking at, rather than an intangible. That's naturally what you would expect it to be referring to. There are other examples. I mean, if I just show you another one, which is in, this is Schedule 3 we're still in. If we have a look at clause 1.6, and that's on page 35. We look at 1.6.1. The obligor shall insure and keep insured the secured assets against, and then loss or damage by fire or terrorist acts. I mean, sensibly, when one's looking at that part of the provision, clearly the secured assets that are being covered by that type of insurance are logically going to be physical rather than intangible. And there are several others that we've given examples of in our skeleton argument. Just for your reference, that's in paragraph 29 of our skeleton, which is in the core bundle, tab 3, pages 32 to 33. Now, just to complete the picture, the Brahma loans or finance agreement and the debenture were assigned on the 3rd of July 2019 and then called in based on a breach of the alleged breach of the information and notification provisions in clauses or paragraphs 1.11.1 and 3 of Schedule 3 that we've been looking at. The entity to whom the assignment took place is a company controlled by Mr. Ferguson, I think it's called Niven, and that's described in the judgment at paragraphs 10 through to 12. And the document making a request for information, which is really the focus, is an email of the 15th of July 2019. It's sort of quoted in the judgment at paragraph 51, but if I perhaps could just show you the actual document, which is in the supplemental bundle at tab 14, page 63. And you'll see it was sent on in July 2019, addressed to Mr. Cousins. It refers to the assignment that's taken place, and then it's got 5 items that are requested. The first of those is for minutes of any board meetings held since entering into the facility. Well, we respectfully submit that's clearly not asking for any information about any kind of asset. The second one is in relation to cash balances, so it just wants the balance for Glint Pay Ltd and its subsidiaries as at the end of each calendar month, and we respectfully submit that wouldn't be falling within the provisions either, if, as we say, they should be construed as referring to tangible assets, but in any event, we would submit nothing to do with location, operation, and so on, which is referred to in clause 1.11.1. Then we have 3, a list of trade and other creditors for Glint. That's really referring to things that are liability. And then 4 details of any intercompany lending or creditor arrangement. And again, we respectfully submit that that's not within the provisions either, because again it refers to intangibles rather than tangibles, which is what those provisions are about, but again is not directed at the types of information that the provision actually requires, location, operation, etc. And then finally, there is a request for any information relevant under clause 1.4 and 1.11 of the schedule. I don't propose to say a huge amount about that particular request, because that does not, in fact, seem to be one that is relied upon in the defence as having been breached for the purposes of the appointment of the administrators. Now, if I could just then turn to probably the first question, really, which is what's the meaning of secured assets in connection with the information and notice provisions, and to how the judge addressed it. And for that, I need to go to the judgment, which is at tab 8 of the core bundle. And if we could go, please, to page 86. And as you'll see from paragraphs 38 and 39, the judge referred to our submission that secured asset could mean something other than all secured assets, and that really followed from the way in which the references worked. And then in 39, he refers to this being supported by the meaning given in the term secured assets in paragraph 1.11.2, which are expressly described as those secured assets which can be inspected and examined after entry onto the obligor's premises. I can see no reason why this approach should be adopted. The claimants accept that the term secured assets can have different meanings in different contexts within the same agreement, and this seems to me to be simply an instance of that usage. So he seems to be approaching matters on the footing that secured assets does have a reference to different types of asset depending on the context. And he accepts that clause 1.11.2 is an instance of that. Now, our point, of course, is that the ordinary natural way of reading clause 1.11.1 is to read it as referring to tangible assets as opposed to intangible. When one talks about operation and so on, that's the more natural way in which you would read those terms. But the learned judge, again, seems to have accepted that is how you potentially could read the terms as in their ordinary meaning. And that's really dealt with in his judgment at paragraphs 42 through to 45 on page 87. But what seems to have been key to his analysis, and it's really set out in paragraphs 45 to 46, is essentially 2 points. He took the view that what was the ordinary meaning made no commercial sense. Wouldn't make any commercial sense for a lender who had a fixed and floating charge over all of the assets and undertaking to restrict the information provision in 1.11.1 to tangible assets. So it's a sort of no commercial sense point in the context of the floating charge. And then his second point is really that ordinarily a floating charge holder would want information about all of the assets and liabilities of the grantor of the charge. That's something he particularly focuses on in paragraph 46. The intention of the parties was to give the holder of the floating charge the right information which would ordinarily be given to the holder of a floating charge. Now, there are a number of problems with the analysis. As to the commercial sense point, with all respect to the learned judge, he's forgotten that the lender here had rights which were rather special, including the right to participate in board meetings, which would give the lender a great deal more information than most lenders ever would have obtained. He also, and this is the second point, has overlooked the nature of the loan. This was a short-term loan designed to deal with a temporary shortfall in working capital of less than a year. And in respect of which, before giving it, the lender had been given the most up-to-date audited financial statements and the most up-to-date management accounts. And one asks oneself rhetorically in those circumstances, why commercially would the lender necessarily want more? And if there really was a desire to have more in the terms of financial information covering topics like assets and liabilities generally, it would have been very easy to do that by having provision for further management accounts to be provided. No difficulty in having wording which provided for that.
But you could argue to the contrary that the fact, I mean, taking your point to its logical conclusion, you wouldn't need, for example, 1.11.1 at all. On your approach, you have the oddity that 1.11.1 covers certain assets.
The oddity in my submission is explained by the evidence that Mr. Strong has given,
Yes.
which is that the foundation for this drafting was a different type of lending, which was fixed asset lending. That they adopted the language from previously, and it stuck there. But all I'm saying is, if they wanted to go further, it wouldn't have been difficult to do it. And I respectfully submit it's not at all uncommon to find within lending which is secured by a floating charge for there to be provision regularly of financial statements, or at least on request, management accounts, etc.
What can we make of that? Or what do you make of that? The fact that this derived from a document which was originally intended to be for more limited lending, a more limited security. The fact is they changed their minds about the breadth of the lending and the breadth of the security. So what, if any weight can be placed upon the history?
Well, simply that they've kept what they had before and not added to it. That's all I'm really submitting. What they seem to have been happy with is this rather special arrangement whereby Brahma could effectively go onto the board meetings and get information. And one can understand why they were comfortable with that, because as you've seen, Mr. Brahman was in contact with the board on a regular basis. So the context is one whereby you've got an investor as well as lender who's in intimate contact with the board members, key board members, and has got this right in his security documents to enable them to formally participate and demand it if there is any disagreement about it.
But how does that help us to construe the words they have chosen to use in the contract?
It explains why they didn't include an additional provision for financial statements, management accounts, information regarding intangibles.
But it's not beyond the realms of possibility that once they extended the security package to include the entirety of the undertaking, they looked at the words and thought, well, information concerning, let's say, the condition and operation of the undertaking would encompass basically everything. So we don't need anything more. I mean, that's a perfectly tenable reading, isn't it? I mean, I know when you look at those words condition used operation and apply it to a bank account
Yes.
or to a trade creditor, it looks rather odd.
Yes.
But if you step back and think, no, that's not the definition of secured asset, it's the undertaking by everything. It doesn't make so much, it makes more sense than that.
All I would submit to you is looking at these provisions as a whole. They are clearly, and sorry, what I'm talking about there are the 11.1 provisions. What they are on a ordinary and natural reading of it, directed at is fixed assets. You can get to something more by a bit of strain, but naturally that's what they're focused upon, and it would not be at all surprising to find, and we submit the evidence shows it, that they were based on a fixed asset loan. And all I think I'm submitting is, given that context, there's nothing uncommercial about it working in the way we are suggesting. It's not uncommercial, which is the judge's basis for his decision.
Well, you're essentially saying this is, you say the restriction to the fixed assets is the natural meaning, and there is no reason to depart from that based on
Absolutely.
commercial
Absolutely.
sense.
And then as to the second point, which is ordinarily a floating charge holder will get the information set out in clause 11.1, 1.11.1. Well, first of all, there wasn't actually any evidence about that at all, and certainly nothing to support the suggestion that floating charge holders get something rather different from regular financial statements, management accounts, that sort of thing. And in any event, whatever the ordinary position would be, would have to be tempered by the fact that we're dealing with a rather special type of loan arrangement here, with a person who is both lender and equity investor, has got the right to go on the board, and all the other provisions that we've been looking at. And the real oddity about the learned judge's approach is that, as you see from paragraph 46, where he gets to is that his construction of clause 1.11 is that it involves disclosure of not only the asset position, condition of the assets, but also details of liabilities, which we respect as much as you just can't get out of those provisions. So what I've been submitting so far is focusing on secured asset, what it means in context. We then also, of course, have to look at the actual request that was made and the information that it sought. I've obviously taken you to the email. It's quoted in the judgment at paragraph 51 on page 88. And the judge essentially held that there was a breach of the information provision because this email wasn't responded to. That's what he finds in paragraph 56 on pages 89 to 90. But, well, with respect, that's a non sequitur, because it really rather depends on what's asked for. Well, what was asked for within the terms of the provision. And the judge really only focuses on two matters, which are cash balances and trade creditors. He says it's the failure to address those aspects that result in the breach. And just to identify which paragraphs of the email they are, we go back to page 88, you'll see that that's paragraphs 2 and 3. Now, the question just looking at paragraph 2, cash balance. The question, of course, is cash balance is really just looking for the amount. We respectfully submit it's got nothing to do with the location, operation, condition, etc., which is referred to in the paragraph 1.11.1 of Schedule 3.
Well, that must be right if that's limited to tangible assets.
And even if it's not,
It's not.
it doesn't actually cover just the balance. Location, I mean, if you're going to strain it to cash, if it's physical cash, of course, if it's in a bag somewhere, yes. If it's in a bank account, maybe if it's held with a particular branch, you might strain the interpretation to do that. But doesn't naturally come within the terminology, just the balance, the amount.
So if I understood correctly, your point there is this isn't asking in what bank, in what account, which might be location. It's simply what's the balance.
Yep.
So a figure, you say, would...
Not naturally within the terms of the provisions of this clause, 1.11.1.
Unless the clause, as I mentioned earlier, is looking more broadly at the secured assets. And this is information relating to the secured assets, which includes all assets and undertaking. So if it's relating to the undertaking, one question might be, what's your cash position?
Well, I can understand you might want to know what the cash position was, but the question is then whether it comes within this terminology of location, condition, operation. In our submission, it doesn't. It doesn't naturally cover that. And as far as trade creditors go, which is the other one, item 3, well, that's not an asset. That's not within the term secured assets at all. That's a liability.
I know you said that paragraph 5 of the email wasn't being relied on, but it is slightly odd the way there is a reference to 1.11 there.
Yes.
Rather suggesting to my mind that this isn't particularly relevant, but the writer, in relation to paragraphs 1 to 4, wasn't relying on that provision.
Absolutely. It would rather suggest that this comes in as a sort of extra, which is thought to be additional to what's in 1 to 4. Indeed.
I can see why it's not relied on, because it didn't really make much sense.
Indeed.
Paragraph 5.
Yeah. No.
Do you accept? I mean, the respondents effectively make the point that if any part of they only need to point to one asset that's encompassed by the request to which there was no response. Do you accept that if any part of the email did fall within 1.11.1, that part should have been responded to?
Well, if we got to cash balances in paragraph
That's the
2,
most obvious.
we might get to a technical event of default with it, or potentially within the parameters of it, but we would then have to go on to look at the next stage, which is was the request for this particular bit of information being made in bad faith, and if it was, does that then mean there's a breach? And we would submit not.
I think the answer to my question is yes, you would
get the first
accept that
stage.
because you go on to the next.
Yeah, they go on to the next stage.
Yeah, thank you.
Now, just one other area which we submit is relevant and really comes into the question whether it was all appropriate for this to be disposed of in the context of a strikeout application. application or summary judgment application, which is whether the judge had in fact got all the relevant material in front of him to make a firm conclusion in the way in which he did, or arrive at a firm conclusion in the way in which he did. Because he seems to have adopted the approach that contextual material wasn't admissible, and he sets out essentially his reasons for that in paragraph 49 of the judgment on page 88. And essentially there seem to be three reasons for it. First of all, that we're dealing with a deed. Secondly, that the debenture was a public document registered at the company's house. And the third point was that it was expressed to be assignable. And the foundation for this seems to be the decision of the Court of Appeal, in particular the judgment of Lord Justice Lewison in the cherry tree case, which I think is quoted or referred to in paragraph 25 of the judgment on page 83. And it was expanded on a little bit in the further judgment of the judge on the question of permission to appeal. Now, we respect to submit that the judge really adopted, with respect, a misconceived approach here, because, firstly, neither the cherry tree case nor any other authority establishes that you cannot consider contextual material when construing a deed. And secondly, neither cherry tree nor any other case has held that you cannot consider contextual material where one is dealing with an assignable agreement. The starting position is that all contracts are assignable, subject to certain exceptions, and usually it's in the context of either an express provision that prevents assignment, or one's dealing with a contract with some personal element to it, some sort of personal service contract or such like. And thirdly, the fact that the document may either go on a public register or be summarised, and the summary entered on the public register, does not mean that you don't consider any contextual material. There's no bright line between registered documents and not registered documents, or unregistered documents. And for that, we refer to the case of Pathway Finance, which itself is really built on earlier decisions of the Supreme Court. If I could just go to that, that's in the authorities at tab 26. At page 902. And rather like our own case, it is a case dealing with a registrable corporate charge. And question arose, this was Mr. Simon Salzedo, and he had to consider whether the approach adopted in Cherry Tree was the one that had to be adopted in this particular context. Perhaps if I could just invite you just to read the description of the background to the decision, which is, I think, on page 902, paragraph 1 through to page 903, paragraph 8. Perhaps if I could just invite you to read that to yourself. if that would be convenient. Grateful. Now, having then set up the background, at page 906, the learned judge at paragraph 25 then states that it's then necessary to consider the public nature of the accession deed by virtue of their registration alters the availability or weight to be attached to extrinsic facts, and he then sets out various authorities related to that. And then paragraph 26 onwards, he then looks at the various recent decisions, which includes a decision called KPMG in paragraph 27. And then in paragraph 28, he then goes on to consider in some detail the decision in Cherry Tree. The relevant and key part of the judgment then appears on page 908. At paragraph 36, where he then refers to the recent Supreme Court decisions. And again, perhaps if I could just, it's really from that paragraph 36 through to paragraph 47 on page 910, which contains the key passage. And again, just given the length of that, it might be more convenient if I just invite you, lordships and ladyship, to read that, if that would be convenient. So it's evident from the decision that there isn't a bright line between registered and unregistered agreements. It very much depends on the type of agreement and the circumstances. And as one sees from that case itself, on the face of the agreement, it would have been evident that there were other things that had been available to both parties that might impact on how they were to be interpreted, and the court could properly operate on the footing that if someone was really seriously interested in the matter, they would pursue various types of inquiry, and those are set out really in paragraph 46 on page 910. Well, in our case, anyone who was looking at the debenture would obviously see that it was based on a finance agreement, and so you would certainly want to be making inquiries about it. And if one was looking at the finance agreement, one would see that there was a considerable background to it too, namely that there is a warrant issue process that has led to the lender not only being a lender but also being a creditor, not only being a lender but also being an equity investor. And on top of that, one can see from the provisions themselves that there had been the supply of information before the finance agreement was entered into, which is not actually recorded in the agreement itself, but just simply referred to. And an example of that is in clause 9.7 on page 9. Information is warranted. And so one would see immediately, if one was a third party, that there had been a considerable amount of dealings between lender and borrower, which could impact on the way in which this agreement operated. And so it wouldn't be appropriate simply to confine oneself to the particular parts of the charge document that happen to go onto the company's register. There's a great deal more background and context to the matter which would have to be considered.
Can I just ask what was meant to be excluded by the judge on this principle? I didn't understand from paragraph 49 that he was excluding reference to the terms of the loan, which is all the things you've just referred to, when construing the debenture. And that would be a strange submission given the charge refers explicitly to the loan.
Yes.
What he was talking about is the negotiating background as being excluded.
Yeah.
And I'm not sure what's covered by that and what you would want to bring in other than the terms of the loan.
Well, we would certainly want to bring in the precedents for the form of the lending, which has been the subject of the drafting of the security document. He does seem to have taken account.
But how would that be admissible? I mean, why is that not simply an earlier draft? And normally, earlier drafts and agreements are not admissible.
It might not. Sorry, when I say earlier draft, actually, I think what we're dealing with here is executed.
Yeah,
lending.
you're saying you want to bring in the previous lending history
Exactly.
relating to real property, which wouldn't be part of the negotiations.
Correct.
Say,
Yes.
so negotiating background is probably not
A little bit of a loose term for it. Yes.
Yeah.
Right, that's more
That's
accurate.
executed
Yes.
lending.
I hadn't picked up that actually there was a previous...
No.
Well, this is
What's the evidence of this? Was there actually previous document?
Yeah, I think you need to show us.
Yes, let's have a little look. It's Mr. Strong's witness statement. I mean, the amount of material which was submitted was obviously, given we were dealing with an interlocutory application as opposed to a trial, not extensive, but he does cover this in the supplemental bundle, tab 52, page 309. And it's both actually. So if one looks at paragraph 118, page 309, it's relevant that, as pleaded at paragraph 34 of the particulars of claim, the majority of the financing provided by Brahma, i.e. to borrowers other than the claimants, was made in connection with the acquisition of real property and or in circumstances where security over real property was provided. And the templates for the facility agreement and the guarantee and debenture derived from drafts or previous agreements that Drama or its owner had used in connection with financing involving real property.
Is that agreements with Glint Pay? It looks to me as if it's agreements with other people.
It's not entirely clear, but it certainly would appear to encompass its previous practice in terms of agreements with third parties.
How would that be admissible? Because how would that be reasonably available to the parties to this agreement?
If the parties were drafting, finalising the agreements we used here, and Brahma produces its form of loan agreement that it's used in all of its previous lending, including executed loans, and the two parties look at it and agree to adopt provisions from that, we would respect to submit that is admissible as part of the factual context. It'd be rather important, in fact. But he takes that part. He does actually refer to that, doesn't exclude it, even though he considers that contextual material is inadmissible based on the cherry-tree approach. But what we would submit is actually matters go a bit further than that, because we know just from the finance agreement itself that it refers to all the communications between the parties and any information supplied in relation to Glint being the subject of warranties, as one sees from clause 9.7 of the finance agreement. That's not set out in the agreement, it's just referred to generically.
But what's the significance of that in terms of construing the agreement?
It's simply that when a third party is looking at the register and sees the reference to the finance document, then goes to the finance document, it will lead them on further.
That's not the question I was asking. That's the question about whether there is material available. It might well be, but how is it relevant to the interpretation of the agreement?
If, for example, the communications between each side included communications that were directed at fixed assets for the purposes of getting information, that could be a relevant matter. That could be an important part of the context.
That sounds like total McCorberism.
I'm sorry, mate?
That sounds like total McCorberism.
Well, all I'm doing at the moment is just addressing the judge's approach, which is that you can't look at context at all because we're dealing with a deed which is registered. That's all I'm dealing with at the moment. And all I'm suggesting is that approach is incorrect. Pathway Finance and the earlier authorities referred to indicate that that's wrong. If we are right about the ability to look at contextual material, then we would expect to submit, you then need to consider whether, among other things, whether the relationship between Brahma and the borrowers was such that Brahma would be expecting and anticipating that it would be providing or be obtaining a wide range of information about these borrowers during the life of this loan. And consequently, there would be no need for it to provide to get information regarding intangibles or further updates of management accounts.
But the most relevant point there may be the fact that the facility agreement provides for attendance at board meetings.
Yes, absolutely.
You don't need to go out.
I don't need to go outside the agreement for that. Yeah. But all I'm just saying, I think the judge's approach was, well, look, if there was anything contextually that you needed to have regard to for the purposes of interpreting, everything had to be in front of the court on the summary judgment strikeout application. Everything.
Well, would you not accept that there is an evidential burden to at least demonstrate the likely existence of some contextual material which would be admissible and which would be relevant to the issue of construction?
I entirely agree and accept that, but we did meet that requirement in the sense that...
Can I just go to one point? We were looking at the witness statement where it wasn't clear whether the financing was the third party, the earlier financing. The judge at paragraph 43 certainly seems to proceed on the basis that there was a document agreed between Glint and Brahma, where Brahma had provided finance for the purchase of certain fixed assets.
Yes.
In other words, I read that as an actual agreement between Glint and Brahma.
Yes.
I don't know where he gets that from.
Yes.
There's the oddity of the brackets, though, i.e. to borrow as other people's vendors.
Doesn't work.
But nevertheless, if that was the, if you like, the basis point for the discussion between the parties that then results in the draft that we've seen, it
Yes,
would be an
but-
important matter to bear in
The
mind.
point my lady has identified seems at the moment to be quite important because you've shown us the evidence of Mr. Strong in paragraph 118, which is what the judge is quoting from later in the paragraph,
Yes.
which does not establish the point about a particular agreement between Glint and Brahma. So therefore the question is, well, was there any evidence of an actual agreement predecessor agreement between Glint and Brahma?
I can't say there was a specific piece of evidence about that, beyond the passage of Mr. Strong's witness statement that I've referred to. But I would submit, even if it was an agreement that had been between Brahma and a third party, if that's the template and basis for what then is produced as the agreement in this case, it would still be relevant and important as a matter passing between the two sides, forming part of the context. Obviously, I entirely accept you can't rely on things that are not communicated. It's got to be passing across the line between the two sides of the contract. But the indications are that that's what this was. And what we have produced is that matter, plus we have other material in the facility agreement itself, indicating that there clearly were communications between the two sides. Also the fact that we have got a lender and equity investor relationship here. That is enough material, I think to use the words of the Court of Appeal in the ICI case, sufficient evidence to indicate that the context may have a bearing on the issue of construction. That's all I'm submitting. And obviously one can't proceed with a summary judgment application on the footing that one's going to have a mini trial with effectively some sort of mini disclosure exercise. It's just got to be up to a certain threshold that you show that there's more to it than simply looking at the agreement itself, and there are contextual matters that ought properly to be considered before arriving at a conclusion. That's all I'm submitting. Should have been the approach here. Now, in terms of the provisions, the respondent's notice has raised not only, it seeks to raise, in addition to what the judge held, was the relevant provision that was breached, paragraph of 1.11.1, the respondent's notice seeks to rely on what's set out in paragraph 1.11.3. This is the sort of notification of claims provision. And essentially, two things have been identified. One is a so-called claim by an entity called AIM Media, which was made, well, the earliest date that's identified is 5th December 2018, or that, of course, precedes the execution of the facility agreement and the debenture. And then the second one is an employment tribunal claim of a previous employee of the appellants called Mr. Davis. Now, we'll perhaps just have a little look at the relevant documents. The letter of aim is in the supplemental bundle, tab 4, page 40. Sorry, no, that's wrong. Tab 1, I should say. Tab 1, page 4. Tab 1, page 4. It's an email from a Mr. Dawn to Mr. Cousins, 5th December 2018. Perhaps I could just invite your Lordship to again read that. It's quite a short email. My Lord's had a chance to look at that. The first point we make about it is, of course, the date. It's preceding the debenture, and the notification provision, which is in clause 1.11.3, that's on tab 3, page 36, is, we submit, clearly one must be forward-looking. It's looking at what may happen after this deed is entered into. In terms of the past, it's covered by other provisions. It's about shall promptly notify. That's the opening wording of 1.11. This predates the document. So that's the first point. Second point is it's not a claim at all. It's actually, when read as a whole, it's a request for information, which, if not answered, may result in a claim. And thirdly, it is not, I'm using the words of paragraph 1.11.3 here, it is not in connection with all or any part of a secured asset. It doesn't relate to a secured asset at all. And fourthly, the evidence is that it was already known about. That's addressed in Mr. Strong's evidence at paragraph 135. It's in the supplemental bundle, tab 53, page 313. Sorry, I said 53, I should have said 52. And it's towards the end of 135. Brahma, being the lender, as at the time of each of the claims, was fully informed by the claimant of each of the claims. So we respect to submit that's just a non-starter as a potential breach, and the judge is right to reject it. The other matter is an employment tribunal claim, Mr. Davis. That's addressed in the judgment at paragraph 63, back in the core bundle, tab 8. It was for unfair dismissal and whistleblowing. And we respect to submit the learned judge was right in his approach on this as well. Firstly, because again, it's got no connection with a secured asset, and nor would it, by virtue merely of the passage of time, come to be connected with any secured asset. It would require a lot more than just the passage of time. It would require enforcement steps to be actively taken. And furthermore, it was again another matter about which the lender was already aware. And again, perhaps if I could just go back to Mr. Strong's evidence, which is in the supplemental bundle at tab 52, and it's paragraphs 136 to 137 on page 313. And I draw attention in particular to the opening words of paragraph 137. Moreover, Brahma was aware of the allegation made by Mr. Davis. It makes no commercial sense or common sense for there to be a repeat obligation to inform the lender of what they're already aware of. So we respect to submit on the construction of the relevant provisions which are said to have given rise to the event of a default. There was in fact no breach, whether one's looking at the information request or the notification provision in 1.11.3. Even if we were wrong, and potentially there was a breach of clause 1.11.1, for example, we would submit it wasn't an actual breach because of the limitations on the exercise of the power to call for information. Both what's been described as an equitable restraint, I suppose it could also be treated as part of the express provisions, properly interpreted, or by virtue of an implied restraint. And for that we base our submissions on the line of authority, beginning with the Supreme Court decision in the case of Braganza. Now, we have pleaded that the purpose...
Could you just show us this?
I'm so sorry, Lord, yes. It's in the core bundle. The particulars of claim are in tab 10, beginning at page 105. If I go to, for example, page 114, paragraph 42, and we plead that Nimoy and Niven attempted to use the assigned debt and security as a tool in their attempts to acquire Glint's business. And then we set out, among other things, the email of the 15th of July, which is the material one that's relied upon. And then there's a number of other matters that are there set out.
Yeah, to be short, but the reason I'm interested in how it's pleaded is the 42A says demanding information to which not entitled. So that's, as I understand it, relying simply on the construction argument.
It goes a bit further. Lord, sorry, I'm just sort of halfway through the exercise.
Right.
If we then go on to 117, after setting out the matters I've just referred to, and also then the correspondence that passed between the parties alleging a default, we then get to 53 on page 117. We first of all say no default, and that's the first sentence of 53, but then we go on to say, in any event, the alleged demand was not made in good faith and not made for an improper purpose. No interest in recovering any sums at all. And B, Niven's lack of interest in recovering sums allegedly due was confirmed during the course of the purported administration. And we refer to the fact that they didn't actually want to receive repayment.
Yes, but sorry, maybe I'm missing something here. But this is a plea about the letter of the 30th of August 2011. That's the demand for repayment.
Yes.
Whereas I thought at this stage of your argument, you were talking about the request for information in the email of the 15th of July 2019, which
Well,
different.
What we would submit is that the demand itself is built on that request for information, among a number of other bits of correspondence.
But at the moment I'm struggling to see where that's pleaded, because there is a very clear pleading that the demand on the 30th of August, not in good faith, improper purpose. I have no problem at all with that.
Yes.
But where is it pleaded that the request for information on the 15th of July 2019 was not in good faith and for improper?
I can only say it's in conjunction with what is set out in paragraph 53, except it doesn't expressly refer in that paragraph to that particular email, but the demand letter itself is built on that email. And on a fair reading of the pleading, we submit it's part of the same material which is being referred to as having been used as a tool to acquire.
I'm wondering if this is a slight red herring, that the focus on improper purpose in relation to the information request.
Yeah.
Ultimately, you need to succeed on showing that the appointment was improper. And this is all part of a, well, I think you do, don't you, in order...
We would say there's 2 points.
Right.
There's the actual event of creating an event of default. Is that creation of an event of default something which is done in bad faith and not for the purposes of either calling in the loan or protecting your position, using the provisions correctly, therefore. And then on top of that, if you go beyond that and then appoint administrators, that's a further step, the particular one that you use for the enforcement. It could have been another mechanism. And whether that particular step is also in bad faith, and we would say it is.
But why do you need the former? Because if you need to establish there is bad faith involved in the whole process. That
Indeed.
Creating an event of default, calling in the loan, appointing administrators was done in bad faith.
Yes.
You don't succeed on that allegation. You're not going to succeed, are you, on a lesser allegation that just the information request was done in bad faith, and therefore that leads to the conclusion there was no event of default.
I entirely accept if there's bad faith, it's going to run the whole way through.
Yeah.
And,
and also, if you fail in bad faith, the failure runs throughout.
Yeah, I think this only really arises because I think a point is taken by the respondent side to say, oh well, when it comes to appointment of administrators, you're effectively sort of barred from running a bad faith point in the way we want to run it. It's not sort of open to you to do that. It's in some way confined, and they want to rely upon a number of things, in particular a provision, I think, in the Insolvency Act and Schedule B1, paragraph 81, to try and do that. We would submit that's actually wrong, and we'll come to that in a moment, but we have got a separate argument that even prior to that particular stage, if bad faith is present, which we say it was throughout, the earlier stage, which you need to get to before you appoint, which is an event of default and a demand, that was in bad faith and invalid. So you don't get to the stage of even the appointment. I think that's how we effectively put it. I entirely accept your Lordship's point that we haven't expressly referred to the 15th of July, but even if we just had to rely on the demand letter as having been made in bad faith, we would submit that would be good enough for our purposes if we were confined to that, which is what paragraph 53 is certainly directed at.
Well, it might be helpful if we have a very quick look at the 30th of August letter.
Yes, my lord. Yeah. Oops. Just want to check we've got that in the. I think it's the one at tab 31 of the supplementary bundle. Yes, it's quite a lengthy.
We don't need to read the whole
lengthy document, but that is the demand letter which I think is being referred to. It sets out the various finance documents, terms of the finance documents, terms of, in particular, of the guarantee and debenture, and then the breaches is set out. That's really set out in page 116, paragraph 4.1, where your Lordship will see reference to the various earlier requests for information, which is said to then be breached.
Okay.
Now, I don't think it's suggested that the pleading of bad faith and improper purposes in some way defective is a pleading, and I don't understand it to be suggested that there isn't evidence of bad faith and improper purpose which would be properly the subject of the normal trial process. If your Lordship would like to know where the materials are, there's a great deal on this topic in Mr. Strong's witness statement. Perhaps if I could just give a couple of references. He covers it really at length at paragraphs 19 through to 56. And then continues with the subject a bit later at paragraph 62 through to 72, and then paragraph 88 and 92 to 98. I mean, what among other things he draws attention to is the lack of interest in Niven, the then lender, in actually receiving repayment of its loan. And indeed, during the course of the administration, they even try to return the money rather than be repaid. And we submit that's clearly because they were interested not in the loan as a creditor, but in the acquisition of the business at as cheap a price as possible, which we submit is an objective in, well, it completely outside of the proper purposes of the loan provisions, but also, and I'll come to this in due course, at odds with the purposes of administration. Now, it's said, I think, that we are wrong in suggesting that the authorities about restraining a lender from exercising its rights in bad faith or for an improper purpose can be directed at the way in which their powers are used under the loan agreement, as opposed to some step in enforcement. We respectfully submit that's wrong. The doctrine we're referring to is one which applies not only in relation to the exercise of rights which are directed at enforcement, but also directed at protection of the security. And one sees that from one of the leading cases on this particular topic. That's the case of Quinnell, which is in the authorities bundle at tab 2, Quinnell and Maltby. And this was the case, I think, where there had been property which had been let, and there was an attempt to remove the tenant by virtue of a mortgage being transferred into the name of the landlord's wife, with her then seeking to enforce the mortgage and thereby get round the protections of the rent tax which were in favour of the tenant. And if I could just take it from the judgment of Lord Justice Bridge at page 11 of the bundle, I think it's page 323 of the report, and it's at just above letter E. I think sentence beginning, once one does that, so it's looking beyond the formal legal relationship. On the facts of this case, it is plain as a pikestaff that the purpose of bringing of these proceedings via Mrs. Quinnell was not for her own benefit to protect or enforce the security, and I just emphasise both words there, protect or enforce, which she holds at as the transferee of the legal charge, but for the benefit of her husband as mortgagor, to enable him to sell the property with the benefit of vacant possession. So it's both protection and enforcement of the security that's being referred to. And similarly, in the judgment of Lord Justice Templeman, if we go to page 12 of the bundle, and just looking at the last paragraph, just below letter E. In the present case, it is clear from the facts and the evidence that the mortgagee, Mrs. Quinnell, is not bona fide exercising her rights and powers for her own purposes as mortgagee, but for the purpose of enabling the landlord mortgagor, her own husband, to repudiate his contractual obligations and defeat the statutory tenancy of the tenant, which is binding on the landlord. Mrs. Quinnell does not even pretend to be acting in her own interests as mortgagee. And she's effectively bringing the action on behalf of her husband. And so one's looking at the substance of the matter as opposed to the mere form. And in that context, he's referring to rights and powers for her own purpose. That's just 2 lines below letter E. So we don't accept one is confined to just looking at the strict mechanism of enforcement that was adopted. One's looking more widely at the exercise of rights and powers which may lead up to the enforcement process, and whether those have been exercised bona fide for the purpose of protecting the security, or whether they're for some other purpose. And we submit in this case that's what has happened in relation to both the request for information and then the demand based on it. Now, the other way in which we put the point is that there is an implied restriction on the use of contractual rights to information of this type, which is of a similar type to the implied restriction that was described in the Supreme Court decision in Braganza. And this only, of course, arises if we are wrong in our other contentions. But essentially, if you are using the right to information in bad faith and for a purpose totally unrelated to the protection of security, then we would submit that is going beyond what the contract permits. And we submit that the situation is quite, well, certainly properly the matter for the subject of trial, and not capable of being simply determined summarily, and is properly supported by authorities such as Property Alliance and Royal Bank of Scotland, which is one of the authorities we have in the authorities bundle, tab 22. That's at page 722. And it involved an instance of the bank being able to exercise our power to appoint a valuer, which then results in a valuation imposing an obligation on the part of the borrower to pay a certain amount in respect of a swap transaction involving LIBOR interest rates. If I could just go to the part of the judgment which deals with this point specifically, which is under the heading of the evaluation claim, and that's at page 762, beginning at paragraph 161. There's a description in that paragraph about the appointment of valuers to assess the value of various properties which were the subject of the charge. And there's then a description of exactly how the point arises as to whether that was carried out in good faith in the following paragraph 162. And if I could then go on to page 765, well, perhaps if I take it up at 764 actually, first of all, at the bottom of the page, paragraph 167, perhaps again I could invite you just to read from 167 down to the end of paragraph 169 on page 765, where one sees the kernel of the Court of Appeal's approach on the topic.
At this stage, are you asking us to consider this point in relation to the request for information and the demand?
Yes, in the sense that both things could only be done in good faith and for a proper purpose. And what we would submit is that the information provision in the debenture is not dissimilar from the type of power being considered in proper property alliance. If there was no restriction of the type that we are saying there should have been, then you could have a situation where there are repeated requests for information, which would be extremely time-consuming and burdensome, just in the same way as it was suggested it would be in the property alliance decision. And you could have it being done every day. It's got to be, in our submission, restricted to legitimate commercial aims, consistent with what the finance documents were directed at. And that, in this context, has got to be for the purposes of protecting the lender's security. Not some scheme to acquire the assets of the appellant companies at as low a price as possible, thereby prejudicing not only the appellants but also their other creditors. Now, the learned judge rejects this as a contention in paragraph 85 of his judgment. So if we go back to tab 8 in the core bundle, essentially he treats the right to information, power to call for information, as equivalent to a right to terminate under the loan agreement, and he refers and relies upon the decision of his Honour Judge Pelling and a case of Lomas and J.B. Firth, and in paragraph 83 you also see a reference to the earlier case of Rockrose. We submit, first of all, the right of the chargee to obtain information is a quite different right to a right to terminate. And in any event, insofar as the judge built his decision on these authorities, and the Britannia and Rockrose case is one of them, he was wrong to do so. The correct approach is not to draw the sort of distinction that he was drawing, for the reasons which are explained in the Supreme Court decision in Tesco Stores, which we have in the authorities bundle at tab 31. Page 1038 is the speech of Lord Legate. Sorry, 1038 I should have said. Perhaps if I could just invite you to read what is set out in the speech of Lord Legate, really actually beginning at the very bottom of page 1037, paragraph 115, to the top of page 1039, paragraph 120. It's the section in which he is addressing whether there's some sort of special rule in terms of how you apply the Braganza doctrine in the context of a termination clause. the court's had an opportunity to read that. I'm most grateful. You will see that the specific reference to the Britannia and Rockrose case, amongst other authorities, in paragraph 117, and the disagreement with the approach being taken there, and the observations towards the end about really the difficulty in looking at a.
So this is a minority judgment. It's not a majority judgment, although it's concurring.
It's a concurring. It's a viewpoint, but in which
you say it's persuasive.
It's persuasive, and it's certainly in the context of our situation, if I can put it like that, which is not a termination situation. It's simply a power being exercised and then a demand being made based on it for repayment. It's not terminating the loan. We submit there's no reason why one shouldn't apply a restriction, that can't be simply done on a whim or in bad faith, and it has to be done in good faith and for the proper purposes of either protecting the security or ensuring that repayment in full is achieved, neither of which we submit were the objectives when the power under 1.11.1 was used or the demand was made based on it. And we certainly submit that that's not in the area which was properly the subject of some form of strikeout, which is effectively the conclusion we're going to judge from. Now, turning to the actual appointment of the administrators, and we do contend that was also done in bad faith and for an improper purpose. It said, well, you can't run a case like that, given that, and this is in the Respondents' notice, there is a provision, paragraph 81 of Schedule B1 of the Insolvency Act, which allows the court, in its discretion, to terminate an administration where it's shown that the appointment of the administrators was for an improper purpose. Just so we've got clear what the provision is, that's in the authorities bundle at tab 36.
1181.
117. Sorry, 1181, I should say. So it's an application by a creditor. That's the class of person who can make it. And it's providing for the appointment to cease to have effect at a specified time. And then in subsection 2, there's a requirement of what must be alleged. Allege an improper motive, and then who has to have it.
It's a bizarre piece of drafting. I mean, surely one would think it would say, if it is shown that there's been an improper motive, then, and so on.
Yeah, it's sufficient to be based on an allegation, on the express wording. Which actually it is really the first point. It doesn't actually require the actual establishment of the improper motive, and that.
Or surely that's implicit, isn't it?
No, you submit, and in fact the authority on it, which is the case of Re Artery, which we've got, which is actually relied upon by on a friend's side, actually establishes that it's sufficient that the allegation is made in good faith and on reasonable grounds. So if I could just show you that, that's in the authorities bundle at tab 30. Sorry. Page 997, I think. And sorry, begins at 996. But perhaps if I could just take up the part of the judgment that deals with it, which is at page 1000, paragraph 22. So you can see the issues identified there. There's an issue as to whether it's sufficient for the applicant to have honestly and or reasonably reasonable grounds.
One of your own decisions, yes.
He did, yes. I didn't plan to take you to that, but he refers to that one and another case. And then, if I could just go on to page 1002, and perhaps if I could just again invite you to read the relevant part. It goes, I think, from paragraph, it's perhaps from paragraph 28 on page 1001 to paragraph 43 on page 1003, where I think he actually reaches the conclusion. If I could just invite you to read that. I'm very grateful. So, although it's in an ideal case, the judge will try to reach a conclusion, it would appear not necessary to actually conclude that there was an improper motive, that the jurisdiction is a discretionary one where the court considers a number of different facets, and strength of evidence of improper motive will just be one part of that. But it's not necessary to actually reach a conclusion on the balance of probabilities. The second point is that the improper motive alleged for the purpose of this provision doesn't have to be the sole improper motive. It could just be one motive. And once the jurisdiction is invoked, it's a flexible one, and the court then has to consider whether the objectives of the administration can then be achieved. So it's a very different type of provision and exercise from the claim that we are bringing forward here. It's also, of course, a claim which is only brought by a creditor, can't be brought by the borrower or company impacted.
So your point about it doesn't need to be the sole motive is that in your claim it does.
We say it is the sole motive.
It is, but it has to be as well.
And well, I can accept that for the purpose of today. Yeah. And so we submit paragraph 81 is not an answer to our claim. Our claim has a life separate from paragraph 81 and can be properly maintained.
Can I just ask this? I mean, the 81 applies to both an administration order and an appointment out of court, as indeed would a claim by the company.
Yeah.
But if it was an administration order, you'd have difficulty, wouldn't you, that the court's order would stand unless until it was terminated.
Yes, I think that's why this effectively provision is for a further order to be made, which will bring things.
So you would have difficulties if this if there had been an application to appoint and the court had made an order, had made an administration order.
Yes, I entirely accept we'd be in a different.
But we're not in that.
But we're not in that. A second point I think is made in the respondents' submissions that there's no scope for some sort of purpose limitation to the appointment administrators because we're working on the premise of an event of default and the right to call in the loan. We respectfully submit that contention isn't correct. The Quinnell case and all the other cases that follow on from it, Dan's view and a few others that we've referred to in our skeleton argument, they're all about, among other things, improper use of powers to protect the security and enforcement of the security. And in the context of an out-of-court appointment of the administrator, that's just simply one mechanism of enforcement in this context. And there's no reason why the doctrine that we've been looking at should not apply in that context. Then there's a further point which the respondents have raised that it's in some way the case doesn't work because if one of the motives of Niven was to seek repayment of their loan, and it was just one of a number of motives that they had, which was in bad faith or improper, that we wouldn't be able to get home, and they try to advance a case on the basis that it's just a sort of collateral motive type case. We don't accept that because our case is that there wasn't just a collateral motive here, and mixed motives. There was a sole motive. There wasn't any interest in the repayment of the loan or the protection of the security. This is a case about something quite different, the acquisition of assets at a discount.
Now, apart from the fact that the judge analysed this as, well, the purpose here was to appoint an independent professional so that the sale could be achieved, apart from that being part of an essential step in achieving the process, the purpose, was there any finding by the judge that, in relation to your allegation, that there was a sole improper motive?
No, he didn't.
So it wasn't found, for example, that as to question whether there were other motives as well, like recovering payment. He didn't say, well, it's unarguable on the summary judgment test that there could have been such a motive.
I've not seen anything to that effect. No. The point he makes is based on the Artery decision. Well, it was enough that perhaps we should go back to his judgment. Actually, it was enough that the administrators were going to be appointed over assets, essentially. This is, I think, the section in his judgment dealing with this begins, I think, at page 91, paragraph 66, and the part that's based on Artery seems to be on paragraph 93, paragraph 73.
Yes, what
and 74, sorry.
Stephen Davis said there, he said there's something similar in the case you've just taken us to.
Yes. Well, it's the same case, actually. Yeah.
Is it the same
It's the same
case?
case, yeah. Yeah.
No, the references
Artery.
are different.
Slightly different reference, yeah.
Oh,
But
it
the-
is.
I'm so sorry, my lady.
No, sorry, it's just the index has got the wrong.
Yeah.
Right, I'm confused by the neutral citation number in the
Yes.
index being wrong.
Yes. But the whole artery passage that's being referred to here is in the context of the judge in artery effectively saying, as long as what you're doing is consistent with the purpose of administration, you can still perhaps achieve the statutory purpose. That's really the opening wording of the quoted passage that's being referred to there. But our point is that administration is certainly a collective process, and it's meant to be directed at doing things which would be for the benefit of creditors generally. Either a rescue of the business, or else perhaps a realization of assets at a higher value than they might otherwise have been, or something of that nature. But we say two things about our situation. One, there wasn't good faith, there was bad faith, and you'll see the reference to good faith as being important in the latter part of the passage in artery that the judges quoted from. But secondly, the objective here, we say, was actually totally contrary to the statutory scheme. It wasn't at all about rescuing the company or realizing its assets at a higher value or anything of that nature, or indeed appointing administrators to be able to investigate the affairs of the company or anything of that nature either. It was all about enabling Niven, or Mr. Ferguson's company, to acquire the assets of the company at a lower price than he might otherwise be able to. And that is not in line with the purpose of administration.
No, the point is made against you that, well, this would have general impact on pre-pack administrations and so on.
We respectfully submit that's just nonsense. Pre-pack administrations aren't about people trying to acquire assets at a discount which they can't otherwise obtain. If that's what it's about, then that's not a proper way to use it.
Well, they can be, or very often are, effectively the creditors taking over control.
But it's an incident of the exercise of a proper purpose, which is that their loan has not been serviced properly. They regard this as a mechanism by which to be repaid, which is a proper purpose, and then the administration goes ahead and, as an instance of it, maybe they do acquire assets at a lower value than they otherwise would have done. But that can't be the sole object of the exercise.
So you say the starting point of a proper pre-pack is trying to secure repayment.
Absolutely, that's what the purpose of it should be and is. It could be that you might have one other of the statutory purposes. You could say, well, the administrator might be able to rescue this company, or he might be able to realise the assets at a higher value than might otherwise be the case in liquidation or something like that. But it's still got to be in line with the statutory purposes. It can't be something that's contrary to them.
Most pre-packs would be in the context of an insolvent.
Yes, I entirely accept that, yes.
And indeed, is it still the case that to get an administration order, you need to at least assert the company is or is likely to become insolvent?
Oh yes, I think you do, as a condition of the
Okay,
application.
for getting an order, but there's no such.
Yeah.
No such requirement. Oh, is there a requirement for a creditor to put appointments out of court can be done by qualifying floating charge holder,
Yes.
the directors and the company, is that it? Can the creditor
That's
do
right.
it?
A general creditor, not that I'm aware of. Not out of court, no.
There's no requirement of asserting any risk of insolvency if a QFCH is appointing.
I think that's right.
Yeah.
In terms of the statutory purposes, just as a reminder of what they sort of comprise and the fact that one's looking at the interests of the creditors of the company as a whole. One gets that, for example, from the provisions of section paragraph 13 rather of the Act, paragraph 13 of Schedule B1, which is in tab 36 of the authorities, page 1175, where the objective of the administrator, what his objective needs to be, is set out. That's 3.1 and 3.2.
Paragraph 3. Yeah.
Yes. And we submit the objectives here were none of those. Actually, they're quite contrary to those.
Well, it could only be C.
And it wasn't C. It wasn't that at all. It was something quite different from that. It was about trying to get things at the lowest price possible. Having unsuccessfully tried to do it by a normal acquisition, which had failed. And I think the next topic I'm going to address is the topic of estoppel. I don't know whether that would be a convenient moment just to break and perhaps return to that fresh after the short adjournment.
Well, would you like to resume earlier than 2 o'clock?
If we could perhaps just start just short before 2, that would be great.
All right, we'll endeavour to do that.
Thank you very much.
Let's try for 5 to 10.